My name is John Rosem. I'm with the Center for Land Use Education and Research. I'm a planner here and have been doing land use education at the center for a number of years. What we'd like to do with this series of videos is to give a bit of an overview of what we do during our Land Use Academy, and particularly focus on this roles and responsibilities for local commissions in these sessions. The session will be broken up into individual commissions, so if you want to just go right to your commission, you can. You can also look at maybe some of the other commissions as well, and that's generally during the training. That's one of the key goals, is to get so that everybody, no matter what commission you're on, you can understand what your fellow commissioners are doing or are mandated to do or required to do. So let's just jump into this, and what I'd like to do in this first session is give a bit of an overview of the sort of why and wherefores of roles and responsibilities. Now, during our training, this session is broken into several parts. The first part is looking at the context of local land use, and this is essentially where the sources of local land use decision making comes from. How do you get to do this? What some of the boundaries on that power might be, and then looks very briefly at some of the types of commissions. The majority of this workshop is focused on looking at the roles and responsibilities of the individual local commissions, and so that's is stated here. We focus on 5 during the workshop: planning, zoning board of appeals, inland wetlands, and conservation. There are many more, obviously, but those are the key 5 that we'll be focusing on. And then finally, at the end, I'll talk about some other issues that are sort of relate to all of the commissions, and just sort of good ways of operating. So let's go ahead and jump into this first part, the context of local land use, and talk about some of that, why you're doing what you're doing. The American system of land use is derived primarily from the English system, and the English system is developed over hundreds and hundreds of years, millennia in fact, and in the English system, particularly in the medieval periods, the sovereign, so the king or queen, basically had total power over the land. It was essentially the sovereign's land to do with what as they wished. Now, the sovereign could grant rights to their land, for the use of their land to their subjects, and these rights that they granted were called fees or fiefs that they could actually give. And this would allow the subjects the right to farm, to live on the land, to build on the land, to hunt, to do other things that they could get to do. So this idea of fief or fief, you might have remembered the term fiefdom comes from this. This all comes from this system. Now, the American system, obviously we had a revolution from the English nearly 250 years ago or so. And so during that revolution, we obviously broke from the way that government was run in England, and so we had to come up with our own system, and that was a lot to undertake. And so we really did borrow heavily from the English system, but instead of having a sovereign, obviously being a king or queen, which we no longer had, we instead made the sovereign state government, and I'm talking about individual state governments. So they really form the idea of what is the sovereign entity in land use. The rights that landowner holds, so individuals, private citizens like you or I, we hold. If we own property, these are still called fee interests, so that ties directly to that old English system. And the power of the state is essentially pretty overarching in terms of land use, but they must give way to federal law. If it was stated in the federal Constitution that the federal government has power over that, so over those specific issues. Now, the state has great control over lands. One of those powers that the state has is this power of condemnation, also known as is eminent domain, which you may well have heard of. This is the power of the state to actually take land and use for a public purpose. The state and federal constitutions both limit these powers, and so if the state is acting within the limits that is stated in the constitutions, then they can indeed take your property. So even though we sort of view ourselves as having ultimate control of our own land, the truth of the matter is we only control certain things of it, and that the state has pretty much enormous, indeed eminent, powers over those properties. Another source of power that governs the state is laws called common laws, and these common laws are essentially laws that have developed over eons, based on the decisions of courts. And so the courts make decisions, and these decisions sort of show our roadmap for future court decisions. And so this sort of all these court decisions over time has sort of formed this idea of common law. And a good idea of common law in land use is the concept of nuisance. Much of the nuisance law that is out there is indeed a common law, comes from common law in terms of its origins. And it's not necessarily state law that's been written down. And the idea of nuisance is just simply citizens should act reasonably towards one another in the use of their property, and in other ways as well. Obviously this seems very reasonable, but oftentimes a very difficult process as well. Another way that the state has great control over the land is through something called police power, and this is a specific definition in the Constitution and in land use, and it simply is the police power is the power of the state to be able to enact laws, and these laws can have can basically tell you what you can do with your property. But in order for these laws to be constitutional, they must be shown to protect the public's health, safety, and welfare. And this concept of health, safety, and welfare comes up a lot in land use law, and particularly when you're trying to write regulations. Now, municipalities have no power in and of themselves in terms of land use. The powers that they have are essentially granted to them by the state. So there's a number of laws, they're called enabling laws, that actually enabling acts that allow the state allows that sort of passes down their power down to the local municipalities. Now, their land use authority is bounded by several things. One is through the legislature's what we call enabling acts, or state statutes that sort of give you the state these powers, and there are boundaries on these powers, and we'll talk about those. Other boundaries of these powers are done by the courts. These are through court decisions that both interpret state statutes and local regulations as well, and these have limit somewhat the power that a municipality has. And then finally, local regulations, which are really the boundaries that you set on yourselves, that municipalities set on themselves, and say that these are the things that we're regulating, and these are what we expect within these regulations. So these three things really are the key boundaries to municipal power. So let's look at the state statute. We talked about state enabling legislation, and most of this comes from the Connecticut General Statute, which you'll often see as CGS throughout this presentation. And these provide, as we said, the foundation of municipal power and set the limits of what you can do and not do. Key sections of the Connecticut General Statutes are for zoning. To allow zoning power is Title 8, Chapter 124, Section 8.1 through 8.3. You don't have to memorize this, obviously, but these are actual specific areas. So zoning is enabled, local zoning is enabled through this act. The state legislature enacted this. Planning and the use of planning commissions is also enabled in the sections noted here. And then wetlands commissions are enacted through and enabled through the acts shown here. So these again are acts from the legislature that allow municipalities to act. Court decisions are another key one. As we said, municipal power is bound by legal precedents that are set by the state and federal courts, so you can't really act outside of those precedents. This court's primary role is to really interpret the acts of both the legislature and also the administrative regulations that might be put forth. So they are the interpreter of these acts. And they also oversee disputes between a community and private rights. So looking at what the community would like to accomplish and saying whether these overstep perhaps private rights that are set forth in the constitutions. Generally during these disputes, there's this idea of a presumption of validity is what they call it. And what this means essentially is that the communities, the local municipalities, are given a lot of leeway. The courts are not in the business of doing local planning and local regulation. So what they do is they look to see if you've overstepped your boundaries. So as long as you're acting within the boundaries and you have good, clear, rational approaches to what you're doing, by and large, the court will not try to second guess you on those. A good example of a landmark case, particularly in this case, a landmark case regarding the power to zone your land, to create zoning regulations, was Euclid v. Ambler. And this is a U.S. Supreme Court case back in 1926 that actually was the first time zoning was tested. And this is, in this case, Euclid, Ohio. This is a suburb. Euclid, Ohio is a suburb outside of Cleveland. And Ambler Realty Company was a local landowner that was, I'd say, upset by the new zoning that Euclid, Ohio, had put in place. This was the first test case of zoning in the United States, and indeed, obviously, since we all have zone, or most towns in Connecticut have zoning at least. This was obviously decided in favor of Euclid, Ohio. You'll oftentimes hear this concept of Euclidean zoning, and that idea of Euclidean zoning is this traditional zoning, which comes from this case. So just a little something for you to throw around when you want to talk about it. Anyway, third boundary on power is local regulations. These are really the things you get to decide, and this is the ultimate source of local land use decisions, as it says here. There are three basic types of local regulations. First is zoning, which we just talked about. The other is subdivision, and another is inland wetlands and watercourses regulations. That all of these are key types of regulations that most municipalities have. Now, interestingly, when drafting regulations, when you're actually writing news or rewriting zoning or subdivision regulations, or your inland wetlands and watercourse regs, you're in this very powerful kind of legislative capacity. You're writing new laws, and that's a legislative role. And so that's a very, very powerful role. You really are in your most powerful role at that point. Now, once you've written those regulations and you've adopted them, you shift hats. You're now an administrative capacity. Now you have to follow the regulations that you already wrote. So this is kind of a dual role that you have as a commission, and you have to make sure you sort of keep those straight. You can't. So in other words, once the regulations are written, you have to follow them just like your applicants have to follow them. You can't rewrite them in the middle of an application. In other words, you have to. If you're going to rewrite your regulations, you have to sit back and do that in a separate capacity. Go through a separate public hearing process, approve them, and then again you're back to your administrative capacity. So understanding when you're writing regulations and drafting regulations, and when you're just being an administrator and applying those regulations, that's very key to have in your mind. Finally, just looking at some of the commissions that are out there. They essentially have a series of regulatory commissions. These are just some of them. There can be others. There's also a lot of non-regulatory commissions as well. And these are important commissions to as well, but even though they don't have a regulatory function, they can serve an advisory function. They can also do key business for the town that some of the regulatory boards just either don't have the time or the ability to do. So all of these commissions are important in trying the town doing their key planning and regulatory roles. So the rest of these video broadcasts will focus on the individual commissions, and these will be divided by each one of these. I encourage you to go through them all, but at the very least, listen to the commission that you're serving on, and then to try to go down to the last section looking at other issues that really apply to all of these commissions. Thank you.